To amend the Code of Sussex County, Chapter 72, Article 2, Section 72-16 through 72-28, and Chapter 115, Articles Roman numeral 4, 5, 6, 7, and 8, Sections 115-20, 115-25, 115-29, 115-34, 115-37, 115-42, 115-45, 115-50, 115-53, and 115-58 regarding affordably priced rental units and the Sussex County Rental Unit SCRP program. Mr. Whitehouse.
Thank you. Mr. President, members of Council, I'm joined by the team this morning, which is Mr. Robertson, Ms. Nauman and Ms. Dupont-Palmer. If in case there's any questions, Council may remember this from the public hearing that was held on June 28th of this year. Council can recall back to that date. At the conclusion of the public hearing, Council left the public record open for receipt of additional written comments for a period of 2 weeks. I can confirm that during that period we received 11 additional written comments and submissions. They have been scanned and included in your paperless packet and circulated. Other than that, I have no additional comments to report, and I will yield to Mr. Robertson to provide a brief overview. So, sure. If you want, I'll drive the presentation.
Yeah, you can drive it, because as everybody here knows, I'm not good at that. Just as, if you want to flip to the first one, this is a brief overview, and it sort of just gives you a bit of the timeline. On March 29th of 2022, the ordinance was introduced. And then on April 28th, 2022, the Commission held a public hearing. Then on June 9, 2022, the Commission approved the ordinance with some recommendations on some just, I think, constructive revisions that they considered with regard to the ordinance. And then, as I think Mr. Whitehouse just mentioned, on June 28th, 2022, County Council held its public hearing and kept the record open for comments until July 12th. And we just heard from Mr. Whitehouse sort of what those comments were. And then continuing with today, going forward, we're going to review the comments and hopefully get some council feedback and direction. And then, because on an ordinance like this, it's complicated to try to do it on the fly and get it right. We're going to try to present an updated ordinance reflecting council's feedback for final discussion and deliberations, which will ultimately then flow into the second meeting, which will finalize the ordinance edits. And sort of as we just went through on one or two of the ordinances we just dealt with, we'll have to go almost line by line for any changes that you want made to the ordinance before we approve the whole thing ultimately. And that's the part that takes some time just to keep straight, because this is a fairly comprehensive ordinance, as you all well know. So these were one of the ones we heard a lot about was concerns related to the by right nature of the ordinance. And by right, as it says up there, means that there, as proposed, would not be any public hearings. There would be essentially a site plan review, which is not a new process. We have site plan review all the time for commercial projects. Actually, in the C1 district, which you're permitted to do 12 units an acre, and with that, there is no public hearing currently. If somebody wanted to redevelop a piece of property, like, I'll give you an example, and I'm dating myself a little bit, but there used to be an Ames right sort of at the entrance to Rehoboth, and that's zone C1. That property now houses townhouses on it behind where the Outback is. That never saw a public hearing, so just because it was C1, it was site plan. I point that out because we're not creating a new framework here. The site plan review without a public hearing actually exists in code.
Can I ask you a question?
Sure.
And I asked you earlier, just in case members of the public, because I have been asked this question. Currently, site plans are not subject to public hearings, and that's by code.
Right.
And that's the way it's been. So, leaving that intact is not a change to the code if this were adopted.
No, that's correct. It's a process, that shows up every Thursday. There are other business items for site plan review.
Kind of an ministerial type.
Right. So what happens is, not to get too far in the weeds, but somebody comes in with a site plan that's prepared by an engineer. Mr. Whitehouse's staff goes through that with a fine-tooth comb, and they are going to make any changes that are required by our code. They would get, assuming that's the case, it would be put on a Thursday night meeting agenda for other business. It would get preliminary site plan approval. Then it still needs to go to all the state agencies, as I like to call it, the car wash of agency reviews. And once that happens and it gets further revised, it would come back to final site plan review. the preliminary and the final, there is not an opportunity for public comment, but that, to your point, is the process we currently have in code today.
I just want to make sure the public
Right.
understands that if this were adopted, we're not changing that.
Right, right. And I think, to your point, Mr. Schaefer, it's important for the public to understand, too, that there still is quite a bit of scrutiny that happens with it, not only by county staff, but also all the state agencies, Conservation District, and everybody else. Some of the thoughts behind the public hearing or the no public hearing process, it does create a strict framework for an approved development. As we've said, these applications or these projects could only be built in specific growth areas, which are the town center, the developing area, coastal area, and planning and zoning recommended the commercial area, which is an area in our plan, not the commercial zone districts, but it's a commercial area, it's a color on our future land use map. Number 3 is additional requirements include the SCRP set-asides of 30%, utilities, open space, and buffers, building height and density limits to 12 units an acre, interconnectivity, sidewalks, and proximity to DART. What the ordinance does provide is predictability, as we've said, I think, throughout this process for the applicant, and most importantly, it answers the need for workforce housing. And the 5th item that we've talked about before is the county's only seen one SCRP development built after more than a decade of the current program due to the significant headwinds, as we call them, applicants face. Thinking about that, we've talked about it, and I thought it would be helpful to actually look at, sort of the history of how these have gone. Instead of talking about the abstract, let's look at the ones that have come through Sussex County. So, Mr. Whitehouse, if you want to, this is the history of affordable housing here in Sussex County. And this is based on what occurred at planning and zoning and then ultimately county council's action on it. So these are the ones that we've had. The first one was Diamond State Community Land Trust. This project, as I said, it received a lot of opposition, and the application was denied at the Planning and Zoning Commission level. Ultimately, as I think some of us here know, the county was sued with claims including a violation of the Fair Housing Law, and the county's insurance ultimately paid $750,000 to Diamond State Community Land Trust because that application was denied. In full disclosure, neither Mr. Moore's firm nor mine represented the county in that matter. And in addition to that, Sussex County was charged with a fair housing complaint, and that did end with a consent decree in federal district court compelled by HUD, which we have been following and are compliant with, and were released from that project. But we have changed a lot of our processes as a result. So, we had a public hearing on that one. It was a subdivision, so it stayed at planning and zoning. There was a lot of opposition. It got denied, and there were consequences. Coastal Tide, this one's been known, just for disclosure, under the applicant's original name, which was Rick Banning, and then it was the Cottages of Arbordale. Now it's Coastal Tide. That's the one that did get built. It's behind the Home Depot on Route 1. It was, and it is our SCRP project that exists in Sussex County. At that one, again, with the P&Z record, so I'm sure there were at least as many at council. There were 46 letters in opposition, opposition petitions with 144 signatures, 24 speakers in opposition during the hearing. Ultimately, council approved it and reduced the overall density, which also limited 6 affordably priced units from that project. As you all may recall, it's come back through for some additional units, but that was what happened at that time. The other one was Nassau DE Acquisition Company, LLC. This was an SCRP project. They had gone through the preliminary steps with our community development and housing folks and also planning and zoning. There were 53 letters at P&Z in opposition to the project, 13 speakers in opposition to the project, and ultimately county council denied the project and no SCRP units were constructed on that one. The fourth one was Ashton Oaks. This was not a county SCRP project per se, although the developer proffered a way to provide affordable units, but was really similar to our SCRP program. At that hearing, at the P&Z level, there were 20 speakers at the hearing, and the record was left open for more. That application was ultimately approved, but the county and the developer were sued as a result. Ultimately, that approval was affirmed in court. The point of all this is that every single one of these that we have had a public hearing on, there has been substantial opposition to. 2 of them resulted in lawsuits. The denial of them resulted in a HUD enforcement action against Sussex County. One was denied outright, eliminating any SCRP units, and the other had its density reduced. I point that out just because that's some evidence of past practice, and we've certainly heard with the comments in this hearing that there is a need for affordable housing, and that I think a majority, I don't want to say all, but a majority of everybody, a strong majority, said we need to have a method for affordable housing in Sussex County. However, when you actually see one that requires a public hearing, there's substantial opposition to it. And the issue with that is that if we continue to have public hearings, that's going to have a chilling effect on any of these projects going forward. With this, what's proposed without public hearings, there's predictability. There's predictability for landowners who are wishing to sell to somebody who wants to do an SCRP unit. There's predictability for the developer knowing that they will be able to get it without a public hearing. There's predictability for the county and the Community Development and Housing Department because they know if these are applied for, they will occur. And I think there's predictability for the folks that need affordable housing in Sussex County that it will occur. You can see why everybody who's tried this, it's been a gauntlet, and that has a chilling effect on somebody wanting to do workforce or affordable housing in Sussex County. There's got to be a matrix that they're going through of why run the risk of having public hearings and either getting sued or denied or whatever, when we can eliminate that with specific guardrails in place on the type of project, where it's going to go, that guarantees that there's protections for surrounding property owners. But in the end, we know we're going to get affordable housing for the people that need it in Sussex County. So,
thank you very much for bringing us a history lesson there.
You're welcome.
And making sure we knew that Mr. Moore and you weren't involved in that. So in full transparency, I was the guy involved in all of that. So thank you.
I was involved
appreciate
in it
that.
on the back end. Our firm had a conflict with it, so we couldn't do the public hearing. And I don't know that I don't mean to say that the outcome would have been any different or not, but
It wasn't fun.
Going through the fair housing process with HUD. I mean, we were in federal district court on that, and as I said, we had a consent decree. In fairness, I think it was also, though, there was a lot of good steps that came out of that. We do a lot of things differently now with how we promote affordable housing and how we handle housing in general. Even the remarks that we make at the beginning of the public hearings that I make and Mr. Moore makes came out of that. So there were a lot of lessons learned that I think were also positive to Sussex County in going through that. It was a difficult process, but I think we made some positive changes as a result. So if you want to flip to the next slide. So these are the kinds of points that were raised in addition to the public hearing. So the first one is the number of CRP set-asides at 30%. Is that something we want to keep or adjust that number? There was the calculation of comments about the calculation of the SCRP rental rates, which I'm going to defer to Ms. Nolman to explain on those. Not only can I not do PowerPoints, but I'm a little weak on the math side of things. The proposal, will they allow, there was a question about whether the proposal will allow these developments to be built anywhere in the county. The answer to that is no. There are real strict guidelines. Like I said, it's the town center, developing area, coastal area, and if you adopt planning and zoning's recommendation, it would include the commercial area. And I wish Mr. Medlars was still here, one of the bigger driving forces is going to be the availability of central sewer, because you really can't do that kind of density without central sewer. You just can't fit things on a property. Then the other one was the question about proximity and distance to the DART routes. The County Planning and Zoning Commission, there was sort of and I'll describe it as a chicken and egg kind of discussion. Should it be more flexible so that the developer can obtain written confirmation from DelDOT that if you build it, we will come with a DART route, versus an existing DART route, which may be more limiting. If they can get DelDOT's cooperation and confirmation that they'll put one in, well, then we should allow this to go through. The idea being, though, that we want to make it so that public transportation is in close proximity to where these developments should go. And then the other one was the need for a look-back clause. That actually came up, I think, in Planning and Zoning and also here at County Council. What that means is that do we sort of set a time period at which we're going to look at as a county whether this has worked or not, or whether there's anything that should be improved or changed. The current, actually, Chapter 72 currently says in there, this is a living, breathing document, the words to those effect, and therefore changes should be made if necessary. The comments were maybe to be more specific than that and say that,
more of a characterized as a pilot program.
Right.
That would have a built-in review period.
Right, right. Where you say, okay, and I would make it, in my opinion, I would say no sooner than 2 years, because if this is adopted and then a developer takes advantage of it, they're going to have to acquire the property, design the property.
There's a lead time.
Yeah, the preliminary, as we talked about with Mr. Schaefer, and then final site plan approval, and then build it. So you want to see if it's actually working, to see what changes may need to be made.
So how are you going to say that council shall be required to have a public hearing review of the document?
Yeah, and we've done that before, although I can't think of when. But say this ordinance shall be reviewed within fill in blank 2 years, 3 years of the date of its adoption.
Well, listen, while you're on that slide, I don't want to just drop this out of thin air later on during a motion, but item 3, I guess I plan on or would like to amend that. I guess we'll call it geographical areas of the town centers, coastal area, developing area, and I agree. I personally agree that commercial areas should be included, but 113, I believe, is going to be denied access up to East Redden Road in the very near future when DelDOT's working on that, to also include from East Redden Road to the municipal boundaries of Milford within 2,640 feet of the right-of-way or the right-of-way of the access road, and also include Route 1 from the 5 Points intersection to the municipal boundaries of Milford with the same language, 2,640 feet of the right-of-way or the right-of-way of the access roads, because I think both of those, particularly Route 1 is going to be denied access all the way up to 16 very shortly, and probably up to Milford in the not too distant future.
Okay.
But I have no idea what council thinks of that, and we'll get to that, I guess, at time of a motion. But I didn't want to drop that out of thin air at the end of the discussions.
Well, that's actually helpful, because the plan wasn't today to make motions on these, but what we want to do is hear feedback like that so that we can start putting together that cafeteria list of changes to make.
Can I ask another question? Mm-hmm. Item 5, and that reminds me. So, and I read this last night again. So the penalty, say a developer's not following through and delivering the units, the number of units that he's supposed to at the rental rate he's supposed to, the penalty is that the county can require him to pay the difference in a penalty of what those rates were. I'm not asking that very well, but I think you understand what I'm asking you.
And I want to make sure I state that correctly.
And how do you enforce that after the fact? I mean, you can't pull his building permit, you can't.
No,
his bonds are gone.
At that point it's built, and they just decide to.
I mean, how does Brandy enforce that? I mean,
right. Well, so 2 ways. One is that we required there be an annual audit provided that's certified by CPA that's not otherwise affiliated with the developer. So there would be an independent audit that would say, these are what was rented, market, and then SCRP, and the rents generated, and then. What would end up happening is if they just said, to heck with it, we're not renting it to an SCRP family, they would forfeit that rent all of it, and it would go to the Sussex County, into a fund, and I'm paraphrasing, collected by Sussex County, using for housing purposes and administered by the Sussex County Office of Community Development and Housing. So
what teeth do you have to collect that?
well, at that point, if they didn't, then we would be in enforcement with the constable's office, and we'd be in court to collect that based upon what's in their audit or other evidence we would have to recoup that amount.
Do you think you'd be successful in court? Would you need to adopt a?
No, I think we would be. I mean, who knows? I can't predict with the
Yeah.
facts and circumstances, but we're going to have two things. We're going to have, if it's a false audit, some CPA is going to run the risk of losing their CPA, so they're not going to risk that. If we have the audit that says that, you know, this was rented for market when it should have been SCRP, I mean, that's pretty black and white, so I think we'd be in pretty good shape.
There were two other issues that were mentioned I want to make sure we consider. There was the minimum lot size, which I think we sort of addressed, but the question is whether it should be codified. And the other one was setbacks.
Yeah, and Mr. Riley, I know we talked about that previously. So the minimum lot size, we did have that with the mock-ups. It was 10 acres and let's say and 30. Internally, it would be easy to just to say it has to be 10 acres. You know, I mean, you could just do that. But the fact of the matter is, there's going to be some point at which you can't do it much smaller than some number.
Which was
because
the response when we raised the question, but
we could certainly add that. It's not because we have that in the RPC code now, where it says an RPC must be at least 10 acres or 1 inch.
so that's the only point. Should we consider it, you know, codifying it?
And it would be simple enough to do, and there's no right or wrong answer. However, people would just know, okay, I need to have this much land to even start.
Yeah, so no one going to try to do it on 2 acres, which I don't think would work anyway, but that was a concern that was raised.
Because the other issue, just for the benefit of council too, is you have to round up. So, you know, even if you had a really small piece of property, you'd have to have one market rate and one SCRP unit. You know, so you know you need to have some density to make the whole thing work. So, but I don't think there's any issue with. I would say probably 5 acres. You know, maybe 10. I don't know. But we can certainly add that for your consideration. I'll make a note of that.
Food for thought.
Yeah.
It physically wouldn't work on 1 or 2 acres.
No, and it would be probably tight with parking and stormwater management and everything else on 5. So, I'm not saying you couldn't do it, but. Mr. Riley, you said you had 2 points, or was it just that one?
Setbacks.
Oh, okay. Yeah, so the setback one, there was a question, I'm sorry, and then just got sidetracked on the minimum lot size. We looked at that 2 ways. One, we wanted to make sure it would work, and with the mock-ups we did, we know it would work. The other factor on that was because there wasn't going to be a public hearing, we wanted to include that as, again, the guardrail, because keep in mind that these buildings can be built up to 52 feet or 4 stories in height. And so, you know, and everywhere else in AR1, it's 42 feet. And so we wanted to make sure that if somebody had a home in an AR1 subdivision and they had AR1 land next to them, that there would be an assumption that it would at least be 42 feet in height, no higher. So if we're going to make it by right that it could go to 52, there's got to be some additional separation from that, just for light and shadows and things like that. So, and I think there was a question too about the buffer requirement within that. It's not the whole thing needs to be a vegetated buffer. It still just goes right back to our 20-foot vegetated buffer that we currently have in code and currently can be applied to any conditional use for multifamily. So that's not a new requirement there at all.
Good.
Mr. Whitehouse, if you want to do the next one. These were, again, the topics that were previously discussed. One of the things that was talked about, and Ms. Nauman talked about this at some length with us and staff, is eliminate the residency requirement, because, again, that does raise fair housing questions. We kind of batted back and forth, but have a preference within the ordinance for those that live and work in Sussex County. There's a requirement in the code right now, and it was sort of a design standard requirement about the primary views of all the apartments must face on open space. That's one of those that we heard from people that build these projects. They said, we're going to try to design as best we can anyway. There's no need for us to have that. It just creates additional burdens on them. And from our point of view, the ultimate goal is to get the SCRP units. They're going to be integrated into the whole project. It's not like they're going to be segregated or isolated from the market rate units. So that was one of those that just, in terms of importance, it kind of went away. There was a requirement in the walking and biking trails, just build in some flexibility on where they would be located, and then also to amend and interconnect the requirement, again, to permit flexibility. And then amend criminal and credit history standards. That one is just basically if everybody now applies those to an apartment complex. And so it would just be you use what credit and criminal history standards you apply to your apartment complex. And as long as they govern everybody the same, then we're fine with that. Because we did hear from some people that certain, charges they may have had in their past really didn't have anything to do with housing and whether they should be able to obtain affordable housing in Sussex County. So, Mr. Whitehouse, you want to flip to the next one? I think that's it. So we got some good feedback from Mr. Schaefer. And I know Mr. Riley had a couple. What I think we're going to do with our team's sort of head nods is come back to you, as I mentioned, at the next meeting with a more clear laundry list of things, including the ones you talked about today, to consider and sort of get more definite guidance, and then we'll come back to you with an ordinance to hopefully adopt at the following meeting or a following meeting. So, while we have you, is there anything else that anybody else wants to talk about or add or consider or change this morning?
Anything else from council? Anything? And certainly, if anybody thinks of anything in the meantime, you can certainly contact Mr. Whitehouse or Mr. Robertson and let them know, and they can add that to their list of things to discuss.
Yeah. Okay. And just as you've seen it before, I think we did it with the buffer one. It'll be section and line numbers. I move to amend line number whatever, section whatever to say, et cetera, et cetera. So. Okay.
Thank you. Thank both of you. Thank you. And thank you in the back there, ladies.
Thank you very much.
Grant request. Mrs. Jennings.